Okay, let's dive into this. Welcome to today's Explainer, where we're demystifying contracts by looking at the totally fascinating world of the what-ifs. Have you ever wondered what actually happens to a deal when things just don't go according to plan? Or even wilder, what happens when the law decides you have a binding obligation to someone you've literally never even shaken hands with? Well, today, we are exploring the hidden legal mechanics behind our daily transactions and some of the really unexpected duties we might be carrying around without even realizing it.
Here is our roadmap for today. We'll start with Section 1, Understanding Contingent Contracts, then move right into Section 2, Rules for Future Events. After that, we'll pivot to Section 3, The Magic of Quasi-Contracts, dive into the 5 types of quasi-contracts in Section 4, and wrap the whole thing up chronologically with Section 5, The Doctrine of Restitution.
So, Section 1, Understanding Contingent Contracts. Let's get a handle on the basics.
Now, what's really interesting about this concept is how it splits the world of obligations right down the middle. Think about this relatable hypothetical for a second. What if you buy fire insurance for your house? You pay a premium to the company, sure, but they only actually pay out if a fire happens. You both made an agreement, but the main performance relies entirely on a what if. Now, on one side, you have an absolute obligation. This is straightforward. It's unconditional, immediately enforceable, and creates a fixed liability. Think of agreeing to pay $5 for a coffee. You get the coffee, you owe the money, boom, immediately. But on the other side, we have a contingent obligation. This entirely depends on an uncertain future event. It's a conditional liability. The obligation basically just sleeps until that specific event wakes it up.
Under Section 31 of the Indian Contract Act of 1872, a contingent contract is defined as a contract to do or not to do something if some event collateral to such contract does or does not happen. Okay, bit of a mouthful, right? So what does collateral actually mean here? Let's strip away that 19th century legal jargon. It really just means an outside event that's tied to the main deal. The event isn't the performance itself, rather it's the trigger for the performance.
To make this actually work, 4 essential elements must click into place. 1. There has to first be a valid underlying contract. 2. Performance strictly depends on an event. 3. The event must be collateral, like we just talked about. And 4, this is key, the event must be uncertain. If we know it's going to rain tomorrow with absolute 100% certainty, well, that's not a contingency. These 4 pillars are exactly how risk allocation works in modern commerce.
And honestly, these pillars perfectly illustrate why these rules even exist in the first place: commercial necessity. Courts have long recognized that businesses absolutely need to make conditional deals just to survive. In landmark historical cases like Frost v. Knight and Nihadi Jute Mills Limited, the courts firmly established that flexible contingent agreements were essential to keep commerce, insurance, and international trade moving forward safely in what is, let's face it, a very unpredictable world.
Which brings us to Section 2, Rules for Future Events. Let's see how enforcement and voiding actually play out.
Now that we know what a contingent contract is, we need to understand the exact rules dictating how these play out when the clock starts ticking. We know that performance depends on an uncertain event happening or not happening, but what if the event becomes impossible? What if the specific thing you were waiting for simply cannot ever occur?
Let's map out Sections 32 through 35 using a classic hypothetical. Imagine I agree to pay you $1,000 if a specific cargo ship returns safely to port. Under Section 32, which deals with the happening of an event, if that ship sinks, the event becomes impossible, right? So the contract is instantly void. But looking at Section 33, dealing with the non-happening of an event, if I promise to pay you only if the ship does not return, well, if the ship sinks, the non-returning is practically guaranteed. In that case, the impossible event actually makes the contract completely enforceable. Then we have Section 36, and this deals with contingencies that were impossible from day one. Agreements contingent upon impossible events are strictly void from the very beginning. To give you an extreme example straight from the source text, an agreement to pay a sum of money only if a dead person returns alive is completely, 100% void. You just cannot build a valid contract on an impossible foundation.
All right, moving right along to Section 3, the magic of quasi-contracts, obligations by law.
We are pivoting to the second half of our explainer now, and this signals a truly fascinating twist in contract law. Seriously, forget everything we just discussed about parties agreeing to terms. So the crucial point is this. In a normal contract, you have an agreement, consent is absolutely essential, and the obligation arises voluntarily. But in a quasi-contract, it is based purely on the law,
consent is entirely unnecessary and the obligation is literally imposed on you. We are now looking at binding obligations where no actual agreement between the parties ever existed. Crazy, right?
So how is that even possible? Well, quasi-contracts originated from the concepts of equity and natural justice. Stemming from foundational cases like Moses v. McFarland, this legal doctrine was built entirely on the concept of fairness. The core idea here is to prevent unjust enrichment, meaning stopping one person from unfairly benefiting at the expense of another. The law just steps in and says, hey, even though you didn't sign a contract, basic fairness demands you make this right.
Section 4. 5 types of quasi-contracts. Let's look at the specific categories. Get ready, because we're going to do a fast-paced sequence covering 5 very specific everyday scenarios recognized by sections 68 through 72, where the law will forcibly create a contract for you. First up, section 68, supply of necessaries. If you supply essential life necessities to someone legally incapable of entering a contract, say a minor or a person of unsound mind, you are entitled to reimbursement from their property. The law creates the obligation for them to pay you back from their estate, even though they couldn't legally consent to the transaction themselves.
Next is section 69, payment by an interested person. Imagine you are renting an apartment, and your landlord totally fails to pay the property tax. The city is about to seize the property, so to protect your own tenancy, you just pay the landlord's tax yourself. While Section 69 means your landlord is now legally obligated to pay you back, even though they never actually asked you to pay the tax for them. Then we have Section 70, non-gratuitous acts. This is brilliantly illustrated in the case of State of West Bengal v. BK Mandal and Sons. Basically, if someone lawfully does something for you, and they clearly didn't intend to do it for free, and you enjoy the benefit of it, you have to pay them compensation. You can't just take the benefit and walk away saying, well, I never signed a contract.
And what about Section 71, finder of goods? What if you find a lost wallet or a laptop on the street? The moment you pick it up to take care of it, the law instantly treats you as a bailee. It makes you legally responsible for protecting those goods and trying your best to return them to the true owner. No handshake required. Your obligation to care for that item is immediate.
Finally, Section 72, money paid by mistake or coercion. If a client accidentally adds an extra zero to their payment and overpays you, you do not get to keep a sudden windfall. The law imposes an immediate quasi-contractual duty on you to return those mistaken funds. And that completes our 5 key categories.
Let's move to Section 5, the doctrine of restitution, and see how this all builds together.
The equitable anchor of contract law really comes down to this one idea. No person should unjustly enrich himself at the expense of another. That is literally the heartbeat of Sections 68 through 72. It's all about restoring balance, returning parties fairly to their original positions, and ensuring that absolutely no one gets a free ride at someone else's expense. And because of that equitable anchor, breaching a quasi-contract carries the exact same weight as breaching a written one. Under Section 73, the injured party can seek reasonable compensation, restitution, or recovery of money. There's also this really fantastic legal concept called quantum merit, which translates to as much as is earned. It basically means if you perform lawful services, even without a formal contract, the court can step in and ensure you receive reasonable remuneration for the work you actually did. Which brings us to our final thought. We've seen how contingent contracts let us plan for an uncertain future, and how quasi-contracts step in to enforce fairness when no plans were made at all. Knowing that the law imposes binding obligations to prevent unjust enrichment, even without a handshake or a single signature, have you unknowingly entered into a quasi-contract today? Definitely think about that the next time you pick up a found item or accept an unexpected benefit. Thanks so much for joining me for this explainer, and I hope this helps you see your daily transactions in a whole new light.